It's easy. Members, is looking through the law and the changes here in this bill with regard to the definitions. It speaks to adding in a new definition for who a community member is. And it adds in a co-responder who is part of a co-responder community response, as defined in section 2432-3501, subparagraph 8, subparagraph D. And that in their capacity as a co-responder, interacted with the respondent or the respondent's child within 6 months before requesting the protection order, but who is not a law enforcement officer who responded to a behavioral health related call involving the respondent. So here's what it says in 2432-3501. It says that a co-responder response means a model of criminal justice diversion that pairs law enforcement and behavioral health providers to intervene and respond to behavioral health related calls for police service, utilizing the combined experience of the law within law enforcement and behavioral health specialists to de-escalate the situation and help link individuals with behavioral health issues to appropriate services. Makes sense. I don't have an issue with the definition. I just have an issue with who's interacted with respondent within the last 6 months, because as you read through the bill, as I already stated, there is an issue with regard to due process, I believe. I'm sure I'm going to get an argument why there isn't, but due process. So an incident happens where the law enforcement officer comes and a behavioral health specialist goes on the police call with them 5 months and 24 days ago. And now the behavioral health specialist is saying, I think I'll file a temporary petition or file a petition against this individual. Is that reasonable in good faith, first of all? Because in this bill, it also talks about that clinical records of the respondent, when made reasonably and in good faith, shall not be the basis for any civil, administrative, or civil liability. So there's the protection of the behavioral health specialist that needs to be considered, but then for the individual, 6 months later, after some incident occurred with regard to a police call, they now have a temporary order filed against them. Where is their due process? I mean, this does make sense that it should happen within a number of days. It shouldn't happen within 6 months. How does that behavioral health specialist actually, I mean, they may have had one interaction with this individual. Maybe they've interacted with them over 3 days, got them the resources they needed, de-escalated the situation, got them the resources they needed, and that might have been it. Yet this individual could lose, could have their property taken from them, again, back to due process, 6 months later, or 5 months and 24 days later, 28 days later. Could have their property taken from them. So I think the amendment makes sense, even though the definition would still say that they would have to have had interaction with the respondent or the respondent's child within 6 months before requesting the protection order. And then the amendment would require that a temporary extreme risk protection order must be filed within 10 days of the petitioner's last interaction with the respondent. Due process for the individual, safeguarding the behavioral health specialists so that they aren't challenged with saying that they were being unreasonable and didn't operate in good faith because they waited 5 months and 24 days to report anything or to file a petition. Mental health should be about a safe place, not necessarily a legal trap. We've all been trying to encourage people to get additional mental health, to seek mental health. This bill, the way it's defined, and that, 6 months later, 5 months later, regardless of due process, someone could file a temporary petition order on you, I would think would make people think twice about seeking behavioral health. So I think the amendment, L004, just makes sense. It guarantees due process for the individual. It's not languishing out there for almost 6 months. or up to 6 months. It's common sense. And for the institution or for the behavioral health specialist that is now added into here in this co-responder situation. It's in this co-responder situation. Behavioral health specialist goes out with a law enforcement officer, working to de-escalate a situation. Not necessarily their client, maybe not necessarily their patient that they will see for the next 6 months. They may hand them off to someone else. I think there's a question as to whether or not it is reasonable and even good faith if they're waiting that long before they file a petition. So I would urge an aye vote on L004.
Thank you. Is there